That was a beautiful song. Peace and love, everyone. How are you guys?
Yeah. Hey, Mother. Hello, everyone.
Peace and love. Hey, hope everybody's having a good day.
We are.
Peace and
And
love,
you.
everyone.
All right, so we had a very good call on Sunday, most definitely. That was the longest we've ever. I think we went almost 4 hours, if not 4 hours.
Yep.
It was great.
It was definitely very good. We had a lot of conversations about a lot of different things, a lot of different topics. So, I have you all here to this evening. We are going to pick up on the book, and we're just going to do the first hour of reading, and if you guys want to stick around and do a little talking, we can do that at the end. Reading from the book, The Complete Book of Wills, Estates, and Trust. I'm reading from the second edition. I don't know if anyone has been able to acquire a copy for themselves yet. If not, I'm going to go ahead and get started reading. Chapter 7 is titled Spouses, Children's Rights, and Children's Rights to an Estate. I leave to my husband, Dom Witt, the sum of $5 to be given to him at the rate of 10 cents a month because he was so good to me. Wow. From the will of Barbara Witt. Must Dom settle for this? As a surviving spouse, doesn't he have special rights, or can he be disinherited and left with 10 cents a month? And what about children? Aren't we legally obliged to leave them something? As to spouses, most testators do want to provide for them and do so in their wills. But then there are those like Harry Preston, mentioned in the previous chapter, who thoughtfully referred to his wife as a she-devil, a, a fiend in human form. Interestingly enough, however, Harry had the presence of mind, or perhaps heeded professional advice, not to attempt to completely disinherit her, but rather that she shall not receive one more cent than she is entitled to under the laws of the state of Pennsylvania. In doing this, Harry acknowledged, as any testator in this situation must, that most states give the surviving spouse the right to a certain share of the estate, regardless of the provisions of the will. Children are an entirely different matter, even though a parent has a natural as well as a legal obligation to provide for minor children. There is generally no legal requirement that a parent leave a part of his estate to a child, whether a minor or not. This is not to say that children never have rights to contest a will or take a share of a parent's estate, but as we will see, these rights are far less direct than those of a surviving spouse. When the deceased leaves a will.
Mother Shay Marie, can you hear me?
Yes, I can hear you. You there? Can you hear me?
Mother Shay Marie?
Yes, I can hear you. Can you hear me? Hmm. Can everyone hear me?
Yes, mother.
Okay. I don't know. I think my laptop just jumped into airplane mode while I was reading. I don't know what happened. So did any?
She said, no, I can't hear anyone. I'll log off and come back on. She
Oh,
said some smoke in New York or something.
oh yeah. See that?
Oh, wow.
Sorry, I said that making bad
Oh.
jokes. That's me. But I heard everything you said. I heard everything you read.
Oh, okay. Okay. Wow. Hmm.
Oh, wow.
Okay. Okay. There she is, I believe. Mother Mia.
Mother Shay Marie, can you hear me now?
Yeah, we can hear you. We could hear you the first time. Can you hear me?
Can anyone hear me?
We can hear you. Let me put it in the chat. Mm. Okay. Everyone can still hear me, correct? I think. Let me check my YouTube channel because I think I cut us off of YouTube because I thought I might have got switched to airplane mode. I thought it was my connection. Let me make sure. I think. Let me check my YouTube. Okay, so it's still one. All right, cool, guys. We're good. All right. So I'm going to begin this paragraph over again. She says she still can't hear anyone. I don't know what to tell her. I don't know what's going on. And welcome, Shelly. I see you entered the room. Welcome. Glad to have you. I'm not sure what's going on with Mother Mia, but I'm going to continue reading and hope she can get back in and be able to hear. Matter of fact, I'm going to message her. She said, I can hear other things, but not the Zoom. Wow. Okay. This is weird. Mother Mia, not really sure what could be happening. Oh, wait. Okay. Disinheriting a spouse with and without a will. When the deceased leaves a will disinheriting a spouse, most states allow the surviving spouse to ignore or waive the will and take what is called a forced share. The laws of those states that allow a surviving spouse to take a forced share are very specific in the amount that the spouse may take, but this does not mean that questions do not arise. For instance, if state X says that a spouse can disregard the provision of the deceased spouse's will and take 1/3 the estate, does this mean 1/3 of the estate that passes under the will, or does it also include 1/3 of the life insurance as well as 1/3 the property in trust and 1/3 the joint property? It used to be that the surviving spouse's right to waive the will and take a forced share applied only to the deceased probate estate. And in many states, that is still the case. The modern trend, however, extends the right to what is called the augmented estate, which includes non-probate property such as property the deceased spouse placed in trust, depending upon the extent of control and enjoyment, and the deceased spouse retained in the trust. Certain jointly held property between the deceased and others, and in some cases, gifts made by the deceased spouse within 2 or 3 years of his or her death. In those states where the surviving spouse's rights extend only to the deceased the deceased probate estate, it would be a very simple matter for a spouse to disinherit the other spouse merely by creating a non-probate estate. And in fact, that is what the modern day Harry Prestons are usually advised to do if they wish to disinherit their spouses. For instance, if Harry placed all his property in a living trust, Anna Preston's rights to waive the will would not extend to the trust, and she would have received nothing. This could still be the case in states where the spouse's rights extend only to property in the probate estate. But beware of the modern trend to go beyond this. Generally, the spouse's election to waive the will and take a forced share must be exercised within a certain period after the will is submitted to the probate court and the executor is appointed, unless the will itself can be attacked on some other grounds. Little can be done before that. Normally, this involves waiting until the will is submitted for probate and allowed by the court as the deceased's last will. When this happens, the executor is appointed to administer the estate. Thereafter, the spouse must, within the prescribed time, file his or her written election to take the share allowed by law, despite what is provided in the will. This time requirement is usually very law, despite what is provided in the will. This requirement is usually very strict, and must be carefully followed. For instance, Mother Mia is having a bad for some reason, still no sound. My apologies. She says she's tapping out for this one today. Okay. Sorry, Mother. Perhaps you can listen in on YouTube, on the YouTube channel still. I'm not sure what's happening. Definitely don't know. This time requirement is usually very strict and must be carefully followed. For instance, if state Z allows the spouse to waive the will provided he or she files a waiver with the probate court within 6 months of the appointment of the executor, the spouse's election must be made within that period. If it is made a week or even a day late, it is likely to be lost, despite the fact that he or she may have an excellent excuse for being late. 1 second, please. Okay. Many states require that the election can be made only if the surviving spouse lives long enough to make it, while others allow the election so long as the spouse survives the deceased at all. In the first case, if the election must be filed no later than 6 months after the death of the first spouse, then a surviving spouse who died within 6 months of her husband could not make the election. In the later case, even though the surviving spouse died shortly after the first, the executor of the surviving spouse's estate could still make the election on her behalf to take a share of the first spouse's estate. That share, once received by the executor, would then pass to the surviving spouse's estate. If the waiver is made, effectively, the surviving spouse's share, according to the laws of the estate, will generally be given priority over the shares under the will, but not over the debt, expenses, and taxes of the estate. After those are accounted for, then the net estate is arrived at, which is the amount on which the spouse's forced share is based. Once the forced share is paid, the rest of the estate can be distributed according to the will or other arrangement if the forced share involves non-probate property. In some cases, taking a forced share can upset the bequest under the will that was waived. Although this is not usually a consideration of the surviving spouse who waives the will, for instance, say that Osgood has a will leaving $60,000 to each of his two daughters and the rest of his estate to his secretary. Osgood has intentionally omitted his wife, no good, from his will. Since the wife's name is no good, you guys. From his will, since he has a strong hunch she has been seeing another man, but he can't prove it. Osgood's will was prepared by his lawyer and signed by Osgood in the lawyer's office with the proper formalities. After the lawyer carefully reviewed the will with Osgood, who was satisfied with the contents. A few months after signing the will, however, Osgood decided to change it. He made an appointment with his lawyer, and while on his way to the lawyer's office, Osgood suffered a fatal heart attack brought about by the shock of finding a parking spot. Brought about by the shock of finding a parking spot in downtown Boston. Wow. I know this got to be a joke. Osgood's estate consisted of the following items: the home, which he owned jointly with his wife, no good, and 2 bank accounts in Osgood's name, worth about $150,000. Shortly after Osgood's death, his will was offered for probate, and when no good saw that she had been left out, she rushed to her lawyer, Tangle, to see what she could do about it. Tangle tells her she does not have a good case to attack the validity of the will itself, since it appeared to have been properly signed, and there was no indication that Osgood was not competent when he made the will or did not understand the contents of the will. Osgood's will, therefore, was probably valid, and no good's only recourse, Tangle advised, would be to allow the will to be probated and then, within the prescribed time, waive the will and take her forced share as Osgood's surviving spouse. She followed Tangle's advice and did so. Osgood's executrix, the secretary, was then required to give no good her forced share after payment of the debts and expenses of Osgood's estate. In Massachusetts, where Osgood resided, the surviving spouse was entitled to 1/3 of the first $75,000 of Osgood's probate estate and a life estate, and 1/3 the rest of the estate. A life estate is the right to use the funds or property during a person's life. In a case like this, it is usually, but not always, means that the spouse would receive the income from 1/3 the remainder of the estate. No adjustment is made for property or assets that pass directly to the surviving spouse outside the probate estate. In other words, no good would be allowed to keep the home, which was in joint names with Osgood, and in addition, she could take her forced share as described above. Some states require that amounts received by the surviving spouse outside the probate estate, such as through joint ownership, be taken into account when computing the forced share of a surviving spouse. No good's forced share then would amount to 25,000 outright, 1/3 of the first 75,000, and a life estate in $25,000, 1/3 the balance. Briefly, the life estate would consist of the income from the 25,000 and in certain instances part of the principal, depending upon no good's future circumstances. In effect, since this is life estate, it requires the court to set aside the second $25,000 for the rest of no good's life. After no good's fourth share is dealt with, the rest of Osgood's will can be carried out, but obviously the taking of the fourth share will upset the rest of Osgood's will. For purposes of the fourth share, Osgood's estate after expenses consisted primarily of $150 in bank accounts. The jointly held home passed directly to no good. The fourth share reduced the bank accounts to 25,000 plus another 25,000 to set aside for no good's life estate, leaving only $100,000 to distribute. Osgood's will, however, left $60,000 to each of his two children and the rest to the secretary. Clearly, there is not even enough to satisfy the specific bequest to his children, let alone the secretary. So what happens? Although it depends to some extent upon the law of the particular state, the general rule is that unless the testator expresses a contrary intent in his will, the residuary estate will bear the cost of the fourth share. Of course, if the residuary estate is insufficient to cover the fourth share, it has to come from somewhere. So then the specific bequest would be radically reduced to make up the difference. And this is exactly what happened in the case of Osgood's estate. The residuary estate, which was left to the secretary, was not enough to provide the $25,000 share plus the $25,000 life estate. So the excess would be taken from the daughter's share instead of getting $60,000 each. Therefore, the daughters would receive $50,000 each, and the secretary would get nothing, and at least not until the death of No Good. On No Good's death, her life estate in the $25,000 would be over, and assuming the full $25,000 remained, the two daughters would each receive $10,000, the balance of their $60,000 request. Wow. And the secretary will receive the residue, which is $5,000. Wow. As a practical matter, Osgood's executor or his daughters would probably have tried to reach a settlement with No Good to avoid having to tie up estate funds for the rest of No Good's life, but settlement is totally at the option of the estate. The surviving spouse cannot force the estate to pay any sooner or any more than it is allowed under the law. If the state in question required all beneficiaries, including the residuary beneficiary, to bear proportionally the cost of the spouse's fourth share, then in Osgood's case, the daughters would have borne the bulk of No Good's share, since they received the bulk of the estate. That is, since the estate after expenses was $150,000, and each was to receive $60,000. They would each pay $60,000. They would each pay 150 times the fourth share, 150 times the fourth share, and the secretary would pay 150 times the fourth share. But as noted above, this is not the general rule. Not every state has such a complicated fourth share. In fact, most states simply give the surviving spouse the right to take 1/3, or in some cases, 1/2 the estate outright. But short of that, there is very little consistency among the states. Some restrict the spouse's right to real estate that the deceased spouse owned at his or her death, and others include all the deceased property, but limit the election to probate property. Still, others, and this is becoming a trend, as discussed earlier in this chapter, allow a spouse to take a share of the augmented estate, which goes far beyond the probate estate and includes jointly held property. Certainly, gifts made by the deceased before his or her death, and certain trusts created by the deceased during his or her lifetime. Usually, if a state's forced share allows the surviving spouse to go beyond the probate estate, it also requires the spouse to account for non-probate property that he or she received on account of the death of his or her spouse. That is, the spouse would be required to take into consideration the value of all the property she received on the account of the death of the other spouse, including property they held jointly in trust and other non-probate estates or non-probate assets that pass to the survivor. As I said, however, there is little consistency except for the fact that every state has some provision that prevents or is designed to prevent disinheritance of a surviving spouse. In community property states, the spouse's protection is not in the form of a right to elect against the will. There is no need for such statute because the community property laws themselves give the spouse a right to one half of all the property acquired by the spouses during the marriage. Since one half the marital property already belongs to the surviving spouse, there is no way that the deceased spouse could leave it to someone else in his or her will. It is also important to note that the surviving spouse's forced share does not qualify for the estate tax marital deduction. See Chapter 13. Therefore, amounts that a spouse takes as his or her forced share will be fully subject to federal estate, whereas amounts voluntarily given him or her by the deceased spouse will not, because of the marital deduction. It is very common to confuse the spouse's right to a forced share of the estate with the share a surviving spouse would take if the other died without a will or intestate. Although in some states the two may bear a resemblance, they are not the same. In fact, except for those few states where the forced share is by law equal to the intestate share. Arkansas and Minnesota, for instance, the forced share is usually less than the share a spouse would take if the other died without a will. I'm going to drink some water, please. Okay, as described in Chapter 2, when a person dies without a will, the surviving spouse can take from 1/3 to all the estate, depending upon the particular state's laws, whether there are children, and most important, the extent of the probate estate. Does this mean then that if I want to disinherit my wife, I simply place all my property in joint names with, say, my daughter and tear up my will? In some states, yes, but in others, no. As discussed earlier, the trend in many states is to make it harder rather than easier to circumvent the rights of a surviving spouse. It is finally being realized that the intention behind such laws is to protect and honor the marital relationship and to respect, even after death, the rights acquired by marriage. If a spouse is to be given rights to the estate of a deceased spouse, therefore such rights should encompass all of the property that he or she owned and enjoyed at the time of death. It is ludicrous to strictly limit such rights to the probate estate of the deceased spouse, when in fact the bulk of his or her estate often avoids the probate process entirely. and even more ludicrous to allow such rights to hinge upon the existence of a will. Based on this reasoning, a number of a number of states are allowing a spouse to take a forced share of the augmented estate, which, as noted, includes non-probate property, regardless of the fact that the deceased spouse left no will. And for those states that do not yet recognize this trend, I suggest it is only a matter of time. Well, then, exactly what do I do if I am the Harry Preston type, intent upon leaving my spouse the absolute minimum and preferably nothing? Wow. That's mean. Why do people get married then? Oh, that's crazy. Short of giving the property away, not very much. If the trend continues, in the meantime, however, in those states that have not yet adopted the augmented estate concept, there are about 25 of them. You can create a living trust discussed in greater detail in chapters 11 and 12. Name yourself as trustee and transfer all of your property to this trust. It can allow you to enjoy the property so long as you are alive and well. And on your death, and on your death, it can direct that all of the remaining trust assets be paid over to, say, your children or anyone else you designate in the trust. Since this arrangement would avoid probate, it would also, in those states that base the forced share on the probate estate, avoid the reach of your surviving spouse. Unfortunately, it is not something you can absolutely count on since the state laws are changing rapidly. One moment, please. Okay, where was I? Okay, I found it. Since this arrangement would avoid probate, it would also, in those states, be forced. Unfortunately, it is some states, absolutely. Okay, your next best bet would be to give your spouse the minimum amount that the law requires on the condition that if she makes any attempt to get a penny more, she will lose the share you have given her. This does not necessarily guarantee that she won't get more than you have given her, but it does mean that in order to get it, she has to risk losing the share you left her. There are also occasions where a spouse who is not a spouse there are also occasions where a spouse who is not a spouse may have rights on the death of a partner, the common law marriage. Oh, okay. In a number of states, in a couple lives together as husband and wife for a specified number of years, usually 7, then in the eyes of the law of that state, they can be considered married. In such cases, the surviving common law spouse has the same right as a legally married spouse, including the right to waive the will and take a forced share, as discussed above. Since it is not uncommon today for couples to live together for extended periods of time without being married, the rights of common law marriage are becoming a more common concern. Those who do not necessarily want to share their respective estates with each other may find that the death of one after having cohabited for the required period of time might very well produce rights to the surviving partner that were never anticipated. For instance, in New Hampshire, if a couple lives together as husband and wife for 3 years before the death of either, the other has rights to the estate of the deceased partner similar to those of a surviving spouse. To avoid this problem, as well as other complications such as the disruption of the estate by the surviving spouse of a legal marriage, the couple should consider entering into an agreement that fixes their respective rights on death, as discussed later in this chapter. Rights of divorce or separated spouses under a will. Generally, once a divorce becomes final, the divorced spouse has no legal claim to the estate of his or her ex-spouse unless, of course, the terms of the divorce decree call for some sort of payment on death. It is not uncommon, for example, for a decree to provide for a lump sum payment to the surviving ex-spouse in lieu of alimony. Other than in such cases, no liabilities or responsibilities exist for ex-spouses. However, problems frequently arise during the period of time during when the ex-spouses are ex in each other's eyes, but not in the eyes of the law. Just about every state allows for or requires a cooling off period after the initial divorce decree, during which the spouses are still legally married. It usually takes anywhere from 1 month to a year after this decree before the divorce actually becomes legally final and the couple is no longer husband and wife. If a spouse dies within this period, the surviving spouse has all the rights of a surviving spouse, just as if divorce proceedings had never been initiated. And even if the deceased spouse was efficient enough to have changed his or her will, the surviving spouse is entitled to take his or her fourth share of the estate. If the spouse did not get around to changing his or her will, and the will happened to provide for his or her spouse, the survivor would then have the chance of either accepting the request under the will or taking a fourth share, whichever gave him or her more. This potential problem is even more exaggerated when the spouses are legally separated but not divorced, or when they are simply estranged. In either case, they are still considered husband and wife with all the attendant rights on the death of a spouse. In all the above cases, a non-final divorce, a legal separation, and even an estrangement, it is advisable for the spouse with the money to have the other spouse enter into an agreement, even if a price has to be paid for it, providing that in the event of the death of a spouse, the other agrees to waive not to exercise any rights she or he may have to the other estates. If the agreement is properly drafted and consideration payment is given, such agreement discussed below in greater detail can be legally binding and can avoid the problems mentioned above. Effect of divorce on a will. While in most states, marriage automatically revokes a will made before the marriage, unless the will was made in anticipation of the marriage, the opposite rule applies to divorce. That is, as general rule, a divorce does not revoke an existing will. Because of ignorance of this rule, the families of many deceased ex-spouses found themselves sharing the estate with the surviving ex-spouse, who was named as a beneficiary of the will, which the deceased forgot to change or didn't bother to change because he or she thought the divorce somehow changed it. As a result of the clear inequity of such situations, almost all the states have enacted laws providing that although a divorce does not revoke an existing will, it does revoke the provisions of such a will that favor the divorced spouse. For instance, say that Tristan has a will leaving 3/4 of his estate to his loving wife, Izodi, and the remaining 1/4 to his son, Wagner. The will also provides that if Izodi does not survive Tristan, the entire estate will pass to Wagner. After many years of a humorous marriage, however, the music stops and the couple obtains a divorce. After the divorce, Tristan immerses himself in his work of setting the Dead Sea Scrolls to music and so forgets to change his will. Suddenly, one day, while writing an aria for the lead camel, Tristan aspirates on his pinpoint and dies. Wow. When the will is later offered for probate, Isolde arrives to claim her share. She is informed, however, that in Alaska, where they resided, the law provides that a divorce revokes any provisions in favor of a former spouse. And since Isolde was only a former spouse, the bequest to her in Tristan's will was revoked. In such a case, the will is treated or interpreted as if Isolde, the divorced spouse, predeceased Tristan, even though in fact she did not, and so the estate would pass to his son, Wagner. Despite state laws revoking will provisions for a divorced spouse, or in a few states revoking the will altogether on divorce, it is important to note that such may have made on life insurance policies, retirement plans, and the like. Many court battles have been fought and lost in an attempt to recover insurance or other proceeds paid to the ex-spouse as beneficiary because the deceased simply forgot to remove her name. The laws of some states go one step further with this concept of revoking will provisions for a former spouse. And in the in the event of divorce, also revokes the appointment of a former spouse as executor of the deceased spouse's estate. Obviously, it can be embarrassing if the divorced spouse is appointed executrix to administer the estate for the benefit of the deceased's new bride. To avoid creating such a difficult situation, it is a lot easier, less traumatic, and cheaper to simply make out a codicil after the divorce, stating your wishes for the disposition and administration of your estate. You guys there? How y'all doing?
We're good, Mother. Thank you.
Okay, great.
We're good, Mother.
All right. All right, so let's see. I think this is a long chapter. Woo. Okay, yes, a few pages left, but we're gonna try to get through it. Okay, premarital and postmarital agreements and wills. It is interesting that first marriages are almost never accompanied by a premarital agreement, whereas second and further marriages are almost never without one. Whatever the reason, if either party of a marriage, first or otherwise, is concerned with limiting the rights of a spouse on divorce, separation, or death, an agreement should certainly be considered. Here, we will concern ourselves with the use of such agreements to prevent lengthy estate contests and to avoid the disruption of the forced share otherwise available to a surviving spouse. For many years, the law effectively prohibited a married couple from entertaining into legal contracts with each other on the theory that to allow one spouse to sue the other would undermine the family unit, which is the cornerstone of our society. Eventually, as suits for divorce and related property disputes became more common, it was successfully argued that each member of the couple was a legal individual and should be able to contract with anyone, including the other spouse. It is, of course, now widely accepted that for most purposes, a court can enter into a legally binding agreement with each other. A couple can enter into a legally binding agreement with each other. And as a result, couples begin to discover that such agreements could even include to a point their financial responsibility to each other under a variety of circumstances. It should be noted here that a contract to do something that is against a particular law or against public policy will not be enforceable in any event, so that a husband could not avoid by contract, for example, his legal responsibility to support his wife and children. Marital agreements fixing a spouse's right at death are becoming quite common, especially when there are children from previous marriages. Such agreements are available in every state, including the community property estate. Including the community property states. Since the law is different in each state, it is difficult to outline the precise form of such an agreement in every case, but briefly, the agreement would state the share of the respective estates that each agrees to give the other on death. In return for such a share, the surviving spouse agrees to waive all other rights he or she may have to take any further, such as and specifically including his or her right to waive the will and take a fourth share of the estate. Further, the agreement should also contain some provision regarding and jointly held assets that the couple may acquire. If it is desired that the jointly held assets should pass to the survivor on the death of one, the agreement should clearly say so. And if it is desired that the jointly held assets should go to the surviving spouse in addition to other shares stated in the agreement, it should state that as well. Perhaps the most important element to ensure the enforceability of marital agreements is independent representation. Do not allow the same attorney to represent both parties. It is absolutely essential that each party have independent counsel advising him on her or his rights. And many attorneys make it a practice to have the attorney sign the agreements as well, stating that they have explained the agreement to the client and they are satisfied that the client understands the contents and the rights and liabilities involved. Although most marital agreements are premarital, made before the marriage, it is quite possible in most states to enter into postmarital agreements. If, for example, a couple is married for 20 years and decides to fix their respective rights at death, it usually happens after a dispute, but not always. They can at that point enter into a postmarital agreement. Generally, all of the same principles apply here as applied to the premarital agreements, subject of course to the laws of a given state. It can be every bit as binding on the surviving spouse, and like the premarital agreement, it can avoid a will contest. Finally, children's rights under a will. Most people are under the impression that they must leave their children something in their estates, since if they don't, an omitted child has the right to contest the will and take a share of the estate. Perhaps the most common offshoot of this misconception is the practice of leaving one another to a child you wish to disinherit. Leaving $1 to a child you wish to disinherit. In fact, in every state, with the limited exception of Louisiana, a parent has the power to disinherit a child simply by leaving his estate to someone else other than the child. And whether the child is left $1 or nothing at all, she may contest the will. What gave the rise to this practice of leaving $1 to a disinherited child are certain laws based on presumption that parents normally do not wish to disinherit their children. The laws that reflect this presumption provide that if a child is omitted from a parent's will, he is nevertheless entitled to a certain share of the estate. These are called pretermitted child statutes. In general, these laws protecting omitted children are of two types. One is the Missouri type, which provides that if a child is not mentioned in the will, he or she will automatically take a share of the estate, regardless of the reason for the omission. The second is the Massachusetts type, which provides that if a child is not provided for in the will, he or she will take a share of the estate unless the omission was intentional on the part of the parent. In order to show that the omission was intentional, lawyers would have to have their clients who wanted to disinherit a child, leave the child $1, or perhaps have them include a statement declaring their intent, such as, I intentionally make no provision for my son Randolph. When advised of the need to make such a statement, a number of testators have felt compelled to go a step further, embellishing the intentional omission with more colorful comments, such as the New Yorker who left his son the generous sum of $1, which is twice what he is worth. Wow. This is not to say that such language prevents a child from contesting a will. As explained in detail in Chapter 10, anyone who has standing and who has a reason can contest a will, and children who are disinherited are often likely contestants. The point is, there is no legal obligation on the point of a parent to leave something to a child, even though the child may be a minor whom the parent was legally obliged to support while the parent was alive. Sometimes the child is omitted unintentionally because she was born or adopted after the parent made out his will. Because of this presumption in favor of children, most states provide that a child born or adopted after a parent made out the will is entitled to a share equal to the share she would receive if the parent died without a will. As noted above, however, some states after born or adopted child was intentional. As noted above, however, some states will not allow the child to take a share if it appears that the omission of the afterborn or adopted child was intentional. Unfortunately, the question of the intent of the deceased parent is in most instances strictly interpreted so that the intentional omission of a child on the mistaken belief that the child was dead is still an intentional omission. This has led to some very unfortunate results. There have been a number of cases, for instance, when a parent who had heard from a child who has not heard from a child for 10 or 20 or more years omits him from the will, thinking he is dead. In such cases, the omission was intentional and therefore enforceable, even though it was based on a misunderstanding on the parent's part. Note that the language of the will in such cases is important. If the mistaken belief is actually stated in the will as the basis for the omission, then even though the omission was intentional, thereby precluding the child from taking a share under the omitted child law, the child may be able to void that portion of the will on the grounds of mistake. An example would be, because my son John is dead, I omit him from this will. Death and appearance are not the only causes for omission based on a mistake that leaves a child without a share. There have also been a number of cases where the parent omitted the child because he thought the child was not his own, as in the case of Owen Schlock of New York. Owen and his wife, Sarah, were caretakers of a parcel of property in upstate New York. According to the records, Owen's only fault was that he drank too much. Several months after his marriage to Sarah, he heard some rumors around town that Sarah was not true to him. About a year and a half after the marriage, their son, Homer, was born. It was not until 8 years later, however, on a night when Owen came home intoxicated, that he accused Sarah of having connection with someone other than himself, claiming that Homer was not his son. For the next 30 years, Owen continued to make similar comments, but only while intoxicated and never in the presence of anyone but Sarah. Finally, he made out a will, leaving nothing to his son, Homer, who was in fact his son. Under these circumstances, since Owen was of sound mind, he was sober when he made out his will, and since he deliberately omitted his son Homer from his will, Homer was effectively and unjustifiably disinherited, and there was nothing he could do. Wow. As discussed above, there are a number of states, such as New Hampshire and Alabama, that do not require proof that the omission was intentional. In those states, a child not provided for or mentioned in the will automatically take a share of the estate, regardless of the reason for the omission. Interestingly, when a child is improperly omitted from a parent's will, the rights of that child can pass down to the child's children. If the child is already deceased at the parent's death, for instance, say that Mallard asked his lawyer to prepare a will leaving all of Mallard's estate to his 3 children, Huey, Dewey, and Frank. When she comes to Frank's name, however, the lawyer's 3-finger typist misses a few keys and the will leaves the estate only to Huey and Dewey. The will is signed by Mallard without realizing that Frank has been inadvertently omitted. As it happened, shortly after the will was signed, Frank was killed in a car accident, survived by his wife and 2 children. And shortly after that, Mallard died of a heart attack and at the sight of his lawyer's bills. Because Frank was not intentionally omitted from Mallard's will, he should be entitled to a share, but Huey and Dewey came forth and say, personally, we like Frank, and had he survived, we probably would have shared the estate with him, but it's a shame he didn't. Frank's children were never entitled to a share. In fact, those states that have laws protecting omitted children provide that the rights of an omitted child can be exercised through the child's lineal descendants if the child is deceased, and case law supports the fact that the omitted child need not have survived the parent for this to be so. In my example, therefore, Frank's 2 children would have the right to share 1/3 their grandfather's estate because of the fact that their father, Frank, was an improperly omitted child. Remember that any mention of the child in the will is adequate to show that she or he was not accidentally omitted, so that even if the child is merely referred to in some context other than a bequest, such as naming him executor, it is probably sufficient to be considered an intentional omission. Surprisingly, an omitted child does not get his share by contesting the will, since presumably the will was properly executed. Rather, before distribution is made to the other beneficiaries, the child must ask the court to order a distribution made to him as an omitted child under the appropriate law of the particular state. A parent who wishes to disinherit a child must also be careful that the remainder of his estate is properly disposed of under his will, or the intentional omission statement may be useless, and the undisposed of property will be treated as intestate property, as if he died without a will, and of course, the child will take a share of that. Therefore, be sure your will has a residuary bequest. It would be unusual if it didn't, but it has happened, especially with home-drawn wills, leaving all the residue and remainder to so-and-so. Adopted children. For purposes of inheritance, adopted children are treated the same as natural-born children. They will inherit it from the adoptive parent and not from the natural parents. When they are adopted, they lose the right to inherit from the natural parent's estate. This does not prohibit, however, both sets of parents from providing for the child voluntarily. Illegitimate children, unless very recently, until very recently, the general rule was that an illegitimate child could inherit only from his or her mother or not from the father, and not from the father, unless the father acknowledged the child to be his, although the father could, of course, voluntarily provide for the child. In 1986, United States Supreme Court decision changed all of that, holding that such laws were unconstitutional and that a state may not prohibit an illegitimate child from inheriting. The effect of this decision could give an illegitimate child the same rights as a legitimate child, including the right to a forced share if improperly omitted from the will. The effect of this, in turn, could be a force fathers of illegitimate children to acknowledge involuntarily the illegitimate child by intentionally omitting the child from his will. For instance, one might envision a will stating, "I intentionally omit the bastard son of mine." Could this be introduced as evidence in a paternity suit? Okay, guys, I'm gonna stop right there. Oh, well, we got 2 pages left. I'm gonna get this out. Okay. Special family allowances. Every state has laws that offer some protection for the welfare of a surviving spouse and, to a lesser extent, minor children of the deceased in cases where the deceased did not provide for them in his or her will, or where the family requires financial assistance while the estate is being settled. For the most part, these provisions favor the surviving spouse, and amounts allowed for the care of minor children, surprising as it may seem, are usually quite limited. In Massachusetts, for instance, though a widow's allowance is limited only by need and by the proportion the allowance bears the total estate, allowances for minor children may not exceed $100 per child. And as noted previously, a minor child has no right to sue the estate of a parent for support, despite the fact that the parent had the legal obligation to support the child while the parent was alive. Most states, however, do provide shelter and at least for the minor child for a period after the parent's death. Such shelter provisions, frequently called homestead rights, usually allow the surviving spouse and the deceased minor's children to continue to live in the home, even though it may have been left to someone else under the will, at least until the children reach the age of majority. And in many cases, the surviving spouse may continue to reside there for the rest of his or her life, whether there were children or not. Widows' allowances. Actually, widowers are now generally permitted to receive allowances from the estate, but for hundreds of years, such allowances were only given to widows because of the husband's obligation to support and provide for his wife. This is in addition to any homestead allowance. The purpose of the allowance, which is paid out to the deceased spouse's probate estate, is to provide for the care and support of the surviving spouse during the period of administration of the deceased spouse's estate. Knowing how long it can take to settle an estate and considering the fact that distributions are not normally made to beneficiaries for many months after death at best, the probate courts are empowered under the law of every state to order payments made to the surviving spouse from the estate for his or her maintenance and support. The widow's allowance ordered by the courts takes priority over all other debts of the estate and may be paid to the spouse even though the estate is insolvent or being sued or contested. It may be given to the spouse whether or not she is named, as a beneficiary under the will. Okay. And even where there was no will. Furthermore, the allowance is available to the spouse in addition to any forced share she may take or other benefits she received from the estate. Since it takes since it takes first priority, the allowance could, if large enough in proportion to the rest of the estate, disrupt or even reduce other bequests. In fact, if the estate was small enough, it could usually entirely for the widow's allowance, and there would be no estate to administer. Despite the fact that the deceased spouse left a will with the bequest to others, the amount of the allowance is always up to the court, which takes into consideration the size of the estate and the circumstances of the widow, such as age, health, general needs, and manner of living. It is this last consideration that often gives rise to the greatest discrepancies between what the widow thinks she should get, what the estate thinks she should get, and what the court gives her. In one case in Georgia, the widow, Mary Lou, applied to the court for a year's allowance from her husband's estate, which was valued at over $300,000. In Georgia, the procedure was to appoint an appraiser to determine approximately how much Mary Lou would need for the 12-month period. The appraiser came up with the figure of $75,000. After the executor, a bank of her husband's assets recovered from the shop, they appealed to the court on the basis that the amount was excessive. The court agreed and reduced the amount to $50,000. The executor, still unhappy with the amount, appealed to a higher court, arguing that while Mary Lou's husband was alive, he never spent more than $1,800 a year for support of the both of them. Since when did the manner of living warrant an expense of $50,000 for 12 months? The higher court agreed that the lower court was too generous and suggested that the amount of $3,500 would be more appropriate. That was in 1950. Only a year later, another case on a widow's allowance illustrated even more dramatically how the accustomed manner of living has a great deal to do with the allowance. In this case, Millicent Hurst asked the court for a mere $10,000 a month to tide over while the estate of her husband, William Randolph Hurst, was being settled. In view of Mrs. Hurst's accustomed style of living and, of course, the size of Hurst's multi-million-dollar estate, the court granted her request. Although the court has wide discretion on deciding the amount of the allowance and in most cases the length of time it would be paid, it has no discretion as to the persons who are entitled to be paid. For instance, even though a spouse may have legally separated from her husband for years before his death, she may still be entitled to a widow's allowance on his death. And no matter how needy a widow may continue to be, if she remarries after her husband's death, any widow's allowance will immediately cease, and as she is then no longer a widow. The allowance is not automatic. It must be applied for by the surviving spouse within reasonable time after the death of the other spouse. And as noted above, if the executor of the estate or the beneficiaries feel it is excessive, they can appeal the order. Few spouses would voluntarily waive the allowance after the other's death. But if the couple executed a prenuptial agreement waiving or limiting the spouse's allowance, this would obviously have a bearing on the court's order. Since most estates take quite some time to settle, it is a good idea to consider applying for the widow's allowance soon after the death of a spouse to provide quick liquid funds for the support of the survivor. However, if the surviving spouse already has adequate funds, such as from joint bank accounts, etc., as is the beneficiary of the estate as well, she may forego the allowance, use her own funds for support, and simply wait for the estate to be settled. On the other hand, if she is not the only beneficiary, or if there is a substantial number of creditors who stand to take too large a bite out of the estate, then the surviving spouse should definitely apply for the widow's allowance. Woo! That concludes today's chapter, you guys. That was definitely a lot, but very detailed, very informative. We should be well equipped to write our wills out once we finish with this book. How are you guys?
Good. You need to take a drink. Yeah. And
Yeah,
a breath.
yes, I really do. That was a lot. I wanted to have Mother come on and share her testimony about one of the cryptocurrencies that I had shared with you all a few months ago, back in June. It was some airdrops I was sharing, and I was telling people to go and claim these free tokens and everything. So lo and behold, she actually called me today and told me that her coins are, her coins are up there in price. And basically her wallet is looking real nice right now. She has some other things she wants to share with you all as well. So Mother Martin, if you could unmute yourself and come on.
Okay, hello everyone. Can you hear me well? Can you all
We
hear
hear
me?
all that excitement in your voice. I'm upset I didn't get on it.
I'm so sorry, but I hadn't checked my wallets in a while, so I checked them today, and I was so shocked because one of the tokens that Mother Shay had shared on her YouTube a few months back was a cat girl, and so I looked at it today, and cat girl, I have $1,400 in that account in the cat girl wallet. So I was just really shocked because it grew exponentially, because at first I didn't have anything in it. So I was like, oh my God. And I don't know how to trade very well, so I haven't done any of that yet. So
Yeah,
I
I'm
just
gonna have to show you that part. But when you claim the airdrop, about how much did it cost you? Did you purchase any of the coins, or is that just from the airdrop?
it was just from the airdrop.
Okay. Wow.
Yeah.
So you probably only paid about maybe 35 cents for the transaction to go through.
Right. So it was just, I was like, oh my goodness. So I was so excited. So I had called Mother Shay to let her know. And because at first I was frustrated because I was like, oh, I don't see anything, changing. I don't see anything moving. And then I was like, I'm not gonna worry about it. So I haven't looked at it in for months. So I just checked today. So I just want to share that with everyone. And also on my crypto.com, remember Mother Shay when you had talked about the Shiba Inu?
Yes, absolutely.
And on the Shiba Inu, I remember you said that we had to I don't know what you had told us to do to earn extra Shiba Inu for 3 months.
They have an earning section on there for not just Shiba. It's quite a few other currencies as well, but definitely Shiba. And basically it's a form of staking, and you earn a percentage, annual. They have like an annual percentage that it pays, but it pays out so many coins. You are actually accumulating more of these coins every single day or whatever. It actually was paying out every week, every like, yeah, every week, once a week, it would pay you out like 1,000, depending on how much you were staking. So if you had, like, let's say 8 million of these coins, because they're so cheap, you could have got about millions of them for 100, about 50 to 100 bucks. So because they were so cheap at the time, and now the price is going up. So you were staking them, earning a percentage, and it'll pay you out what it wants to pay, a percentage of the actual earning annual percentage. It pays out every week. And then so it just pays you out more coins. So you're actually accumulating more of the asset and not necessarily more money, because as the value of the asset grows, then the amount that you're holding causes the total value to climb up in value. So yes, that is amazing, Mother. So what did it get up to?
For my crypto wallet, I'm at $2,046.
Wow, that's awesome, 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 awesome.
But
And
I had got other wallets as well. I remember you had talked about certain ones like Harmony, Cardano. Um,
mm-hmm,
I have Seller Network,
mm-hmm.
VThor Token, VChain, Sandbox, Silicon, The Graph, Nervous Network, Digibyte, Ellipsis, Reserve Rights.
Wow, okay, you did it up. That's what's up.
Yeah, so Shiba Inu it's up there. It's at $476.16.
Yep, I think has knocked off another zero, and the price is climbing because, guys, it's like less than pennies for one of these, for just one coin. So, it's like 0.00004 or something like that, with a whole bunch of numbers after that. So, like, this is the beauty of cryptocurrency. And you definitely want to take advantage of it right now. The wealth transfer is definitely happening, and it's not too late. Is that even with Cat Girl, it's definitely not too late for you to take advantage of Cat Girl either. So if you want to do that, because the coin is still very, very cheap. And there is a lot of information. I know that the group that I've been learning from, they talk about Cat Girl a lot. Well, they've been actually talking about it a lot the past couple of days, because it's like Mother said, the price just started to climb. So definitely
Yeah.
going to get with her to help her make a trade so she can pull out some profits for herself, because you definitely want to take profits. So Mother, tomorrow, whenever you're ready or whenever you're available, just let me know.
Okay, I'll send you a message on Telegram and let you know when I'm available.
Okay.
I just wanted to share that with everyone because I know with the Shiba Inu right now, to get the 7 million on here, it's
Mhm.
$348.98. And then when I first started, I was only paying like 30 something dollars for that amount. So
Yeah.
it's rising.
Yeah.
Yeah. So, but yeah, I just wanted to share that with everyone.
Thank
Thank
you so
you.
much. Sharon.
I haven't heard of Cat Girl till today.
Yeah, it's one of those what they call meme coins. It's really but what it's turning into a useful coin now. It's they're turning a lot of these what were at first known as meme coins, or they also call them like shit coins. They're making use cases out of them, and it's all type of different projects. You guys, this industry is definitely taking off, and it's so many different. It's really, really kind of hard to keep up with now, because so many different things. They have these NFTs going, that's changing the art industry that I've been telling you guys about. And then it's just so much to really, really keep up with at this point. But it's definitely a wealth transfer taking place. And so Cat Girl was actually a coin that it at the time in June, they were just giving out airdrops. And so this is just when we were just, I have a whole bunch of coins in my wallet right now, in my trust wallet, that are just sitting there doing nothing. And Cat Girl was kind of one of them. But we actually claimed them as airdrops, but you would have to pay like maybe 30 cents in a particular cryptocurrency to be able to, for the transfer to go through, to pay the transaction fees or the network fees. And so this is one of them. And so Mother claimed her free coins and I claimed mine. Me, on the other hand, I don't even want to talk about what I did, you guys, 'cause I'm upset right now, honestly. But I've been in crypto space for a while, so I kind of do a lot of different trading and gambling and trying to do other stuff and maneuver. So I kind of missed out on this one. But like I said, I got a whole bunch of other coins that are probably going to pay off for me. So I'm just happy that Mother, and I'm quite sure quite a few other people did take advantage of the opportunity too, that I shared it with. So I'm just glad to hear that testimony in itself. So that's amazing.
Thank you.
So, I'm feeling kind of silly over here because I mean, not only am I late to the party, but I'm not even sure how to set my wallet up properly. Somebody helped me move I had a little bit of money left in my Cash App that I moved into Bitcoin, and I don't even know how I got it there. But other than that, oh
Okay.
yeah, I have a list of things that I've been hearing that I've been taking notes on, but I don't know what to do.
Okay. Again, Mother, you definitely want to get with me, schedule a consultation, but it's nothing to set up a crypto.com account. It's very simple. I can send you my link, and basically you just really need to download an app. Put your personal information in. I think you're going to have to go through some ID verifications and things like that. But once you do that, you can attach your bank account to it and load some funds on there. Very easy to do, and be able to invest in whichever coins. Crypto.com has a lot of the currencies listed on there. Same thing with Coinbase. And Coinbase has a lot of if you guys don't have a Coinbase account yet, I encourage you to get a Coinbase account and try your hardest to set up one, because Coinbase has educational little sessions on there and they give you free coins just for reading about the coins that they're releasing, and taking a little 3-question quiz about what you just read about, like, and answering it, and they give you free coins right there. So don't knock Coinbase. Definitely set up a Coinbase account too. And that adds up. It can add up like tremendously.
Yeah.
So don't.
So, do you guys have multiple accounts, or
Oh yes. I mean, because I have, okay, you have crypto.com, which is a platform. It's basically an exchange platform where you can buy cryptos. Crypto.com. I'm going to pull it up. But you can buy cryptos on here. You can stake and earn and make more money. Put your cryptocurrencies to work for you and make money over here. There's all type of things you can do over here. They have Visa cards where you'll be able to, yes, where you'll be able to get a Visa card, and you'll actually be able to spend your crypto directly from the crypto.com Visa cards that they have. So you definitely want to check that out. I'm going to send you my link so you can get the referral bonus as well. Once you've spent so much, they actually give you a free $25 in
okay.
cryptocurrency. So make sure you check that out. I'll send you my exact link. Let me put it in the chat for you guys. I'm just grabbing the link. Okay. I'm putting it in the Telegram chat link and for you, and everyone can grab it from there. And I also put the Coinbase link too, because Coinbase gives you $10. You spend your first $100 as well.
Mm-hmm.
So you get, it's just free crypto, and it all adds up and it all grows. You know?
Okay, so a couple things I have on my list to share
Okay.
are Stellar. Do you guys have
Yes.
any Stellar?
Yes.
37 cents right now, or it was 2 days ago.
Yes. Stellar. See now, Stellar and XRP. I shared this in the group with you guys. Let me see if I can put a new screen share on. Stellar and XRP is going to be a part of the new financial system, the new quantum system,
Yep, I heard that too.
along
Yep.
with a couple of other cryptocurrencies, IOTA.
I know that one.
So it's quite a few of them on that network that's getting ready to definitely take off. And as you can see, Stellar has definitely been climbing. I definitely see the difference in my wallet. I also want to share with you. You probably don't know anything about this one. Nexo is another platform that we've been using, or that I've been sharing with you, but I've been using myself and my husband. That you can invest in your crypto. You put your crypto into Nexo, and it does earn daily interest as well. But what it also allows you to do is, if you want to, instead of sell your crypto, now you can actually borrow against your cryptocurrency instead of having to sell it.
Wow. Okay.
Yes. So as the cryptocurrency goes up, you can just repay it back with the what you accumulated or gained from the increase in that currency. You can choose to pay it back. Like right now, I have about $5,000 in my account, and I have, well, it's not five, it's about 45, and I have I've taken out multiple loans up to $1,300 right now. So
What?
as it continues to increase, I can take out more, or I can pay it back or whatever. But yeah,
It's called ISO. That's what I'm looking at.
no,
ISO.
it's called Nexo. I'm gonna put
Okay.
that in the chat as well for you.
Okay.
Yeah, Nexo is another great platform. I've been using Nexo for about 2 years now.
Wow. 2 years. I'm so
Yes,
late.
I started out with a very small amount and just let it grow from there. With some XRPs, and I've been doing a lot of different things over the past couple of years with my crypto, so I really can't talk. Let me see.
Another one that I saw that was inexpensive was called, I'm not sure I got the spelling right, Algorand.
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 That's also a part of this network. I think it's on here somewhere. Yeah, Algo right here, Algorand.
Okay.
Mhm.
Cardano is still pretty cheap to get into.
Absolutely. Cardano's on here too. ADA Cardano.
I
Right.
heard Harmony, do you know about Maddox?
Matic, yes. Yes.
I don't know if I
All
have
of
this spelled right. How's it
Yeah.
spelled?
Matic, MAT, it's Polygon Matic, MATIC.
Okay.
Mm-hmm.
Um, mm, mm. Well, I heard that Celsius is one that pays dividends.
It probably does. I don't have any Celsius right now myself, but it probably more than likely it does, because a lot of these cryptos pay you actually just for holding them. You earn more crypto just for holding them. So I was guys something about Safe Moon a few months ago as well. So those who have Safe Moon, you probably have more in your wallet now than you had when you first got them and purchased them. Although the price hasn't gone up the way we've expected it to yet, just keep holding them. Eventually they will. But yes, it's basically an incentive right now for holding the coin. And then certain coins like that, they will tax you for cashing out on them. That's the only other alternative to it.
And when you say what's an airdrop? Is that just a
Well, an airdrop is when coins are getting ready to be released, and the company or the developers, they are basically giving out free coins as an airdrop.
I see. Is there a particular website or channel or anything you watch for the most current information?
Recently, I haven't even really been sharing a lot of airdrops, because I'm not even gonna lie, I kind of got a little discouraged a little bit, but it was from another investment that I was in, and it was just people started figuring out how to make coins, and what they were doing was geeking up certain coins. This is just recently happened, you guys.
Mm-hmm.
So I had to take a break from it, because I didn't really want to be promoting things that was stealing from people and stealing people's money. But what they were doing was they were hiring celebrities and stuff like that, saying they were putting things on New York billboards in New York, on Times Square, and all of this for these. And there are quite a few of them out there. And it will drive the price up. People would invest in it. It'll drive the price up. And then what they would do is buy out. And so now everybody who is looking for, to be able to, if you didn't pull out fast enough and you just missed out. So
I get it. There was a lot of that going on
there
last
was a
summer.
lot of it going, yeah. And this just was happening. So I really had to just step back, and I tried to just get focused on other things, learning about this trust and this laws, y'all, because that's really what's most important to me, really, anyways. And accumulate my physical silver and gold. But yeah, it was a mess. So I had took a break from it. So I really haven't been following anyone. But now that I see what Cat Girl has done, I'm like, oh man, I should have just kept on with it. Yeah.
Yeah. I just took a chance, mother, because I'm still learning as I go along. But
It
a lot
is
of times,
like a gamble, kind of dealing with,
yeah,
because you just don't know. You really don't know what's gonna happen, guys. Like, especially with this crypto market and stuff,
yeah,
we just don't know. We don't know who's in control of it. Honestly, we don't. So, and then I just started getting just like these epiphanies, like, crypto is basically driven. It just like started dawning on me, even though I've been in it for a few years, learning about it, participating in different things and stuff like that throughout the years. It dawned on me maybe like a year ago, like, this is driven by the dollar, by fiat, if you really think about it. So at the end of the day, it really doesn't have any backing either, besides the value that we give it. So
right.
actuality, crypto doesn't have a real true value besides those cryptos that have that are claiming to have backing in precious metals and things like that. But honestly, we really don't know if these people telling the truth either. You know what I'm saying? Unless you actually go out there to their minefields and stuff like that and see their establishments.
Mhm.
So it's kind of difficult, but this stuff really was like starting to, ponder in my mind, like, this is not necessarily going to last. It's definitely been an amazing and a great stepping stone for a lot of our people, including me, because I have had, a lot of different success with it, and being able to get a lot of different make profits and stuff. So not the kind that I would like, but all anything counts. Anything that I didn't have to go punch a clock for, it all counts. You know what I mean? So
Mhm.
yeah. I mean, I was just getting in where we can fit in at this point, you guys, and seeing where it takes us. And that's why I encourage diverse portfolio and ensuring that you have the physical assets, the silver and gold. That's been my main message.
Mhm.
You
And
know,
what about like copper?
copper, yes, copper, platinum,
Mhm.
mainly all precious metals. And I've been, like I said before, I've been hearing a lot about they're going to be utilizing a lot of the crystals and stuff as well, and that's going to start having more value in it because a lot of the new technology and stuff like that requires it. So a lot of people are now um you know
Interesting.
uh
And I have a
gaining
bunch
with
that.
crystals. Yeah.
Do you remember when I'm about to tell on myself in terms of my age, but I remember going to the amusement parks and those little gift shops used to sell you a whole bag of them, of the crystals for like $5. You guys
Mhm.
remember that?
Oh,
Mm.
never.
I do.
If I you guys you guys are, I'm not going to say you guys are way older than me, but I'm 30. I just turned 38. So no, I don't remember that though.
Okay.
I remember marbles, because I now I'm trying to like really think, like, was marbles crystals? Because a lot of stuff that they put out over the years was things that we really should have been using, but then they put
Mhm.
other stuff out in it to distract us from what we really should have had.
Exactly.
You know what I mean?
Just like in recent times, there's a copper craze, like things that look like copper but are not.
Mm-hmm.
You know what I mean? Like kitchen utensils and different things like that are coming out, and that was
Yes.
the look. But I'm like, that's not real copper.
Right. Right. Absolutely.
Uh, yeah. Okay. So yeah, I'm in my early 50s, but I think I'm 30 something.
Okay.
I don't know how I got
I
here.
have an old soul though. That's why we're connecting so great. Like, I love you ladies. You guys are really, really, like my soul. It's like we're building a soul tribe
Soul
here.
group.
Yeah.
Yep. Yeah, my soul group. Yep.
I
That's
was
so
just thinking about that last night. I was so grateful because I was just thinking about how, because for me, I mean, I live in the middle of Los Angeles and I'm surrounded by people all the time, but I
Mhm.
don't, so I never really feel like I'm alone, but I am because nobody really seems to understand what's happening, you know?
Mhm.
I can
Mhm.
only say so much. I told my neighbors like 3, 4 months ago to start growing things, because I don't want you knocking on my door, you know?
Right.
Or planting stuff. And they were looking at me laughing, like, really,
Yeah.
Maria? And I saw this last year. Last year, I knew all this stuff was coming. And I was in the farmers markets myself. I mean, I work a regular job, but I was also growing microgreens, growing in the farmers markets. And when they turned that into a whole like communist feel with the gloves, the masks, you know, all the rules and restrictions, I'm like, this isn't even fun anymore. I'm just going to take my seeds and hoard them for myself, you know?
Wow.
But But yeah, so many people don't understand what's going on. And I said all that to say that I'm so grateful
Yeah.
for this group, and I'm grateful for the class that Noble Isaiah does on Wednesdays.
Mhm.
And Shay Marie, Shay Marie, I want to say her name right. She does the class on Sundays, the Grow and Show.
Yeah.
Yeah.
Oh, Mother Mia. Yes, yes, yes.
All of that. So I kept asking to find my people, and they're not, physically near me, but to be connected to you guys in this way is a gift. Thank you.
Absolutely. I
Yeah.
agree.
It is truly a gift.
Let's see. We missing Mother Flora today. I love when she comes on.
Oh,
Too, I love her stories. I remember the
Yes.
last class we had, she was talking about Hungary. And it's a beautiful country. I've been there as well. And it's called, the capital is called Budapest, but the city is divided. One part is called Buda, the other part is called Pest.
Mm,
It,
okay.
I didn't know that.
it's really, yeah, it's really beautiful. And the architect, like she said, is out of this world. Yeah. And Croatia is beautiful too.
Wow. Well,
Yeah.
wait to get to some of those places. Most definitely.
Yeah.
I'm just excited. I can't even imagine how, guys, how it's about to be, but we about to really, really be.
I'm so excited. I'm tickled. So I sometimes I'm at home, I just bust out laughing because I'm just like, oh my goodness. I'm so
Right,
excited. They haven't even gotten here yet. I'm just
right.
picturing. It's gonna be so lovely. I can't wait till we all get to meet each other. I
Yes,
really
that too.
I really
Are
can't.
we going to? Are we all going to go to Belize first?
I
Well, I don't know. I know me personally, I'm actually probably about to get out on the road with whom I call my grandma Cynthia, who's my late mother's best friend. And I was telling Mother Bajetta this earlier. She came here. She's from here, but she moved to Arizona. But back in April, she decided to pack up all her things and put it in storage, and she bought her a van, and she decided she wanted to go and just start traveling. So for a few months, she was just, driving around Arizona and California area, just living alone, learning how to live the nomad life. And so she's been here since we came back from California. She's been here in Detroit. But since she's been here, she's been a major help and blessing to me. So I've decided I'm probably gonna, get out on the road and travel with her, and we can hit up some states and try to make something happen, guys.
yes.
Come and visit some of you or something. you know. I don't know, but
What'd you say, Mother? Well, I couldn't
I
hear
didn't
you.
hear
I
her
was
either.
saying I can come and, visit visit, or we can try to set up some type of retreat or something. Because I just realized, people, regardless of what is going on, people are still living their lives, and this stuff is it's not stopping nothing. Like, we can still live our lives. We don't got to be cooped up in this house, not doing nothing,
Yeah,
you know.
that's true. hmm
So
I'm gonna buy me an RV, so
absolutely, yeah.
get get to travel.
Changing the energy and not subscribe to,
Yeah.
what they're telling us we need to be doing.
Mm-hmm.
Yeah. They just trying to keep us closed in because they really don't want us to know what's going on. So,
Right.
you
That
know,
too.
they don't want us to be free thinkers. They don't want us to ask questions. They just want us to be one track minded and nah. So I get it. Yeah. But
Yeah.
yeah, we can do that, Mother. We can, make some arrangements and, set up some type of retreat or, whatever, because I'm willing to do that. I hope y'all don't mind pets, but they don't shed, so you don't have to worry about that if anybody is
Wait, what kind of
allergic.
pet? What kind of pet?
I have a Yorkie poodle.
Oh, okay.
And I have a Shih Tzu Pomeranian mix, and I
All
have a
the
Shih
dogs that
Tzu.
I want.
Well,
Wow.
two of them are rescued. The little Yorkie poodle, I found her roaming the street a couple of years ago. She weighed 4 pounds. She was in such bad
Oh,
shape. And then my Shih Tzu, I got her from a couple. Oh, they treated her so bad. She was so emaciated when I got her. And then the Shih Tzu Pomeranian mix, I got him from a breeder. Yes, he looks like a cotton ball.
wow.
Mhm.
Yeah, he's sweet.
Okay,
His
that's
name,
cool.
yeah, his name is Yogi. The little Yorkie poodle, her name is Lola, and the Shih Tzu, her name is Sophie. Yeah.
I just hoped it wasn't like a ferret or
Oh
some wild.
no, 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 no,
That
no.
happened to me once. I couldn't stop screaming. I could not believe it. Walked into somebody's house and that thing came running. I was like, "You got to be kidding me!"
Oh, no, I love dogs, but they're small, so but yeah.
Yeah.
And they don't shed, so if anybody's allergic, you don't have to worry about that.
Oh, no, I don't have a problem.
Me either. But yeah, so but
Where does everybody live? What states is everybody in?
I'm in
um
Michigan.
yeah, I live in Texas. I'm Mother Martin. I live in Texas. Yeah.
Okay.
Never been to California, but um
I
As
don't
we,
know what to say
you
about
know,
California. I really don't.
have you been
well,
there your whole life?
No, no, no. I'm originally from Ohio,
oh,
Oh, okay. Okay.
and I've lived a bunch of places actually. I lived in Atlanta for 10 years. I tried to live in Spain. I don't know what I was thinking. I
You
think
didn't
I
like
mentioned that
Spain?
before.
You,
Um,
you didn't enjoy Spain?
well, I guess there's a difference. I call myself trying to move there,
Mm-hmm.
but as a vacation in terms of beauty and the artwork and the buildings and things like that, I mean, it's beautiful.
Yeah, I've
But
been there. It's nice.
when you
Wow.
think about actually trying to live there, well, at least this was back in 2015. No, that's a
Mhm.
lie. That was back in 2005 and 2006. I thought I was going to live there. And I just felt all by myself because I was only Marina person, I was only black person, brown person over there.
Oh, wow.
And those people kept trying to touch me, kept trying to look at my teeth.
oh,
I was almost raped twice. I had to
oh,
fight my
hell.
way out of both of those situations.
Oh, wow.
And yeah, I mean, it was quite a story.
I was over there during that time. Well, I was in Europe then. Yeah, I was there. I was in Europe for like 5 years before I came back to the States.
Wow.
And I was stationed in Germany, and then I was stationed in the Netherlands. And
Mm.
yeah, but yeah, I enjoyed being there. It was a little bit slower than here in the States, and it wasn't as stressful. When I came back to the States, I cried. I was like, oh, I should
I
stay in the
cried because
States.
I was so happy to be back on American soil, and I never thought I would feel that way.
Wow.
I think if you would have had, some friends, you would have been fine. But if you're there by
Yeah.
yourself, I get it. It can be difficult and challenging, but yeah. But yeah.
But I actually want to go back. Surprise, surprise. I didn't make it to Portugal. I wish I went there.
Went where?
Portugal?
Oh, I didn't get to go there. I always wanted to go, but I didn't get the opportunity. But yeah. Did you like the food in Spain?
No. I was like, if I see one more jamon y queso, I'm going to throw up.
Oh my goodness. Did you
That's
travel
awful,
anywhere
right?
else?
I mean, I went to a lot of places. I mean, at some point, I did have some good food that felt like good Mediterranean kind of food, like the paleta. Am I saying that right? I forgot what it is. Popular dish over there.
Mm,
Of course, the seafood was good, but
Mm.
wow.
yeah, yeah.
And
You can drink a lot of wine over there for sure.
their wine is really good.
The wine is amazing. Yeah.
It is. European wine is really good. It's really good.
And
Mm.
their food is clean. You know, all the stuff we put in our food over here, they absolutely don't do over there. I don't know
Right.
if it's changed,
They're
but
very organic. They're very organic with their food. Yeah,
mhm.
they are. It's different. But yeah, hopefully we all can meet up one day and travel and talk and you
That's right.
know, I'm excited. I know it's gonna
Ooh,
come. I know
goodness.
it's gonna happen. It's gonna happen.
Yes, it is.
Yeah. So but that's you gonna leave your kids, mother Shay Marie? You could just gonna go on the road and just leave your kids at home?
That is, she is put me in I do a little traveling though. She is put me in the spot because you guys know my grandbaby is about due
I
in the next
know.
month, so I don't know.
You
We
said you didn't say grandbaby, you said my baby. That's what you said.
probably
That baby get here, you're not gonna want to leave. I promise you.
right.
Oh my goodness. Well, I mean, well, if you could probably do little short spurts here and there and then go back home, but I don't see you being gone for a long
Because
period of time.
my younger two though are mostly with their dad. Like my youngest son right now, he's struggling. He with this with going to school, and I don't blame him because you guys know they just quarantined my daughter again. This is her third time being quarantined.
From school?
Yes, and she feels like she's the only one, but they're claiming that it's from another girl who's supposed to had it. But why do you guys keep quarantining my child? And it's
Wow.
kind of weird because her daddy's not really saying anything or communicating with me and let me know what's going on. So I don't. But I'm trying to talk to my daughter. She just turned 13 and she knows how I feel. My kids know how I feel about this. So the only reason why they're really in school now is because they're over there with their father and he works for us. He's like an assistant principal or something like that. So he thinks that it's important for them to be in school and all of this crap.
Mm,
And so it's like a battle. I'm like battling with so many different things. All these zombies that just want to stay stuck in this same old rigmarole of stuff that has
right.
not been working for us for forever.
Right. Right.
Like,
I,
man. So right
wow.
now I don't know. But my daughter, she stays with her father right now. My son, he's 15 and he
Hmm.
think he's grown anyways. And but he's here with my son, and he's 20. My daughter, she's 19. So I mean,
Right.
they pretty mature. I'm not really worried about them.
That's good. That's good. I just can't imagine being a parent today because it's just so many stresses. You're stressed,
Yes,
know,
yes.
and you
Someone
just
put on the YouTube, and I've been feeling like this for a while though. That the only reason that I'm really not afraid of death, but the only reason why I really wouldn't want to die is because I don't want to leave my children here without me. Like I want to wait till they long grown and I know they good. You know what I mean?
I understand. Trust me, I really truly do because my friends always tell me, you don't understand, you don't have kids. I'm like, it doesn't matter. I understand. I'm like, if I had some kids, I'd be all up in their business. Like, what? Like,
Right.
I'm your
That's
parent.
what I always say.
I'm gonna
Yeah.
give you your space, but you get out of line, I will snap you back. Don't play.
Hmm.
I feel like I'd be snapping everybody around them, you know. What are
Hmm.
you teaching my kid? What did you say? What? Yeah, I mean, I just feel like I'd be up in arms all the time.
Yeah.
Yeah, me too. Yeah.
And I even kind of like, because even myself, I was not conscious. I was not this conscious. So I kicked myself in the ass for letting it go, letting a lot of things go on for as long as I did, and now coming into these knowledges, it's like, man, in these awakenings, it's like, man,
Yeah.
kind of dropped the ball, but it's out of fear and it's out of, you know, the fear that I know for me, it was out of the religious fear based thing that my people had up on me. I know that's where mine come from. It was really, really heavy.
Right.
Mhm.
You know, and still healing from it a little bit, you know? So
Yeah. Yeah. And me and you talked about that earlier about, the healing and things of that
yeah,
nature. And yeah, we've been through a lot as a people, but we're slowly waking up,
mm,
and that's important. And we're waking up, for the next generation because I I wouldn't want them to experience, the things that previous generations have experienced because I just sit here and think about, oh my God, if we just would have been in the know,
right,
oh, we would have
right.
been forced to be reckoned with,
Thank you.
you
Thank
know. And I'm a rebel at heart, so
Yes, me too. That's what I'm saying. Like,
and even when I was growing up in school, my mom used to have to always come up to the school because I wouldn't let no teacher talk to me crazy. And my mom was a PTA president. She used to be a substitute teacher. She used to be around the corner from and I had a teacher, she used to talk to our class so crazy one time. And I'm just like, why are you talking to us like that? She's like, get out my class. I'm like, gladly. And that day, my mom was around the corner. She was substitute teaching in the 5th grade. And then I went to the principal office. He was like, well, you need to apologize. I'm like, I'm not going to apologize till she stopped talking to us crazy. We don't want to hear this every day.
Mhm.
Mhm. So, but yeah, so, and even now with us waking up, we still going to be a force to be reckoned with when that time comes. And that's what they are afraid of. So,
definitely.
you know, bring it. I don't have no problem with it, but people got to be willing to, be ready to battle. That's the thing too.
Absolutely. And I want to make sure you guys saw I put in it. Did you guys also the gentleman in the group commented, say he called his phone company and they told him yes, that's the correct way about the remittance slips and
Now,
for your bill payments.
the remittance slips, like, I know if you send it in, then he said something about a cashier's check or something.
Yeah, so he did another. I'm gonna put that one. I recorded it earlier. I'm gonna put it in the chat too. But so he did another one, kind of going into it a little bit more, and
Oh,
it
okay.
is really simple. Just like he said you just call them and let them know that you would like to pay by remittance. Any company, any bill is already prepaid. And he's even saying that apart your and he's going to probably be drop. I don't know if he did it or not yet, but he's going to be dropping a video about something about when you sign your lease and your apartment, when you make that, when you pay your security, what is it called?
Security deposit.
Security deposit. That is supposed to cover your stay there for your entire lease.
Oh wow.
Yes. So I'm waiting on that video to drop. Even though I know I'm not leasing or anything, but I know a lot of people could use that. You know,
Yeah.
I
Oh,
could. I'm hearing this crazy. You could have never told me. I don't know how I ended up in Los Angeles. You could have never told me that I would be doing some of the stuff I said hell no to 15 years ago. Like, the parking situation, the rent is as much as a damn house payment.
Mhm.
I don't know how I've been doing it here, but I have.
are you going to remain in Los Angeles? Are you planning on moving somewhere else?
At the rate that the politics is going, I can't stay here. I
Yeah,
just
that's
don't know
why
if
my
we're
husband, my husband was born and raised there, and he left way before I knew him. He left there when he was younger, moved to Alabama, built up a life there in Alabama for 14 years. And then recently, before we met, which was about maybe 3 to 5 years before he and I met, had just moved back to LA with his family and everything. Then he flew here in 2017 and we got married. But my husband was born and raised there. He says the same thing. He said he tell his people all the time, I don't know why y'all don't want to leave this place. Y'all crazy.
Wow.
And it is to live there.
He
And
says, I don't know why you want to leave LA.
why they wouldn't want to
Why
leave.
they wouldn't want to.
To
Well, I
leave
used
Los
to think that when I lived in Atlanta too, when people were moving over there from California. I'm like, are you kidding me? But I had never been here.
Mm,
With palm trees and warm weather. Now I have appreciated that, especially as a tennis player. I've appreciated the weather and the fact that there's never a shortage of things to do in terms of live music or concerts or lectures or whatever, you know.
mm-hmm.
But yeah, but what's going on now is crazy. What's going on these streets? LA is like number one in the country in terms of homelessness, and it's getting really bad.
That's bad. That is bad. That is horrible. But me, I
Well,
was first time there was just this. We were there in July, and it is beautiful. And I'm I'm like, we need to move here, honey. He's like, I ain't coming back here. But,
wow. That's great. I mean, Atlanta is it's getting to be too Hollywoodish and it's
yeah,
so crowded. They drive crazy. Like I'm from Georgia. Where I'm
yeah.
from, I'm probably like 35 minutes from, downtown Atlanta, but it's too much, I have cousins, they like, you coming back here to live? I'm like, no, y'all can keep that. No. Mm-mm.
That's where we.
Yeah.
That's where we. It's ironic you say Georgia because when he flew here, we got married, and then we went. We had already made arrangements with other people and stuff like that to actually move there. So we had actually flew there to go and find a house, whatever, but things didn't work out and we went through a whole lot of different stuff when we was there and ended up
Mhm.
for 2 months and then we came back here. And so much just must not been meant for us to be there. I don't know.
No, it's not. I mean, I miss my family and stuff like that, but I'm just like, no, it's too much. And I like Texas. It's open. You have so much space and land is green. I mean, I'm not far from Austin. I'm by like 45 minutes from Austin, but if I want to go to the city, I can. But I like the quietness. I was telling Mother Shay Marie where I just moved. It's so quiet. The only thing I hear is the train. That's it.
Um,
Yeah. So I like the peace and quietness because a lot of those major cities, uh, it's I think something's gonna happen in these major cities, and
Mhm.
if people
Mhm.
don't pack up and move,
Yeah.
to outlying areas, it's gonna get bad,
Yeah. I agree. Yep.
But if you ever
Yep.
come out here, you have somewhere to live, you have somewhere to stay, Mother Shay, and everybody else, come visit.
oh yes, I'm planning on it.
You're
Trust.
you're welcome, so I'm sending out the invitation. So if you ever come this way, like I said, I'm about 45 minutes from Austin. So um I would love to have you all here just to sit down and talk, have tea, eat dinner, whatever.
Fellowship, absolutely.
Yeah, so but I appreciate you all so much. I really truly do.
And I appreciate you all as well. Oh, I'm gonna get on off of here. We've been on here a while. This was another great time together. So tomorrow we will have meditation for an hour at 6 p.m. I'll see you all tomorrow.
See y'all
Okay.
tomorrow. Peace and love, everyone.
Love. Have
Peace
a
and
good evening.
love.
And I see your message on Telegram, Mother Shay.
Okay.
Okay, thank you. Bye bye.